Breaking news, Blake Lively is breaking her silence on her Instagram stories. And you know that's the good stuff. You don't get the good stuff from People Magazine, from TMZ. It's always going to come on her Instagram stories.
There is a particular kind of silence that comes before someone decides they have had enough. It is not dramatic. It does not announce itself. It just ends. And when it does, the person on the other side of that silence tends to say something that surprises everyone, including themselves. Blake Lively broke her silence this week. Not through a press release. Not through a carefully timed interview on a sympathetic morning show. She did it the way she has always done it when things get serious, through her Instagram stories. Short posts, measured language, polished fonts. And underneath all of that polish, something that reads less like relief and more like strategy. The question worth asking is not what she said. It is why she said it now, what she carefully chose not to say, and what the court ruling she is celebrating actually means when you read past the statement and into the 152 pages that produced it. Because this story is more complicated than it looks. And that gap between how it is being presented and what is actually happening is where the real conversation lives. To understand why this moment matters, you need to understand how we got here.
First Instagram story she posted, official statement, my godly attorney for Blake Lively. It is completely unsurprising that Brian Friedman does not understand the court's actual ruling. He didn't even argue the summary judgment motion.
Blake Lively and Justin Baldoni co-starred in the film adaptation of It Ends With Us, a story about domestic abuse, survival, and the complicated ways people find their way out of painful situations. The production wrapped, the press tour began, and then, in December of 2024, Lively filed a legal complaint against Baldoni, his publicist Melissa Nathan, his crisis manager Jed Wallace, and the production company Wayfarer Studios. Her core claims were serious. She alleged that Baldoni had engaged in conduct on set that she believed constituted sexual harassment. She alleged that when she privately raised concerns about that behavior, the response was not accommodation or accountability, but something else entirely, a coordinated, covert campaign to damage her reputation before she could damage his. The word coordinated is important here. This was not Baldoni posting a frustrated comment online. According to Lively's complaint, the effort involved hired professionals, digital strategy, and a specific intent to flood the media with narratives that would make her look difficult, unstable, and unreliable as a source of her own experience. Baldoni denied all of it. His legal team, led by attorney Brian Friedman, pushed back aggressively, arguing that Lively's claims were exaggerated, legally unsupported, and in some cases, outright fabricated. The litigation has been running for months, and last week, a federal judge issued a summary judgment ruling that sent parts of the case forward toward trial and dismissed others.
He's now spinning. Had to bring in another law firm for the trial, and just last week was reprimanded by the court for having filed legally frivolous claims. We already know what that really means.
That ruling is what Blake Lively is responding to on Instagram, and it is worth spending some time understanding what it actually said, because her lawyer's version of it and the court's actual language are not quite the same thing. A summary judgment ruling is not a verdict. It is a determination made by a judge, before a jury ever sees the case, about whether the evidence is strong enough to even justify going to trial. If a judge finds that the evidence is too thin or that the law does not support the claim, the case ends there. If the judge finds that there is enough for a reasonable jury to potentially decide in the plaintiff's favor, the case moves forward. So when Lively's legal team says the court found sufficient evidence to proceed, that is technically accurate. It means the case is going to trial. It does not mean she has won. It does not mean the court has concluded she was harassed or retaliated against. It means a jury will now get to hear the evidence and decide. Here is where things get nuanced in a way that the Instagram statement glosses over. Lively's lawsuit contained multiple claims. Among the most significant were her allegations of sexual harassment under both California and federal law. Those claims did not survive summary judgment. The judge dismissed them, not because the court found that the behavior she described was acceptable or that Baldoni did nothing wrong. The ruling specifically acknowledged that a person in her position could reasonably have perceived the workplace environment as reflecting what the court called a gendered and sexualized view of women and a disregard for their privacy. That is not a small acknowledgement. The court is essentially saying that what she experienced was the kind of thing that could reasonably be understood as creating a hostile work environment. But the harassment claims still failed, and the reason why is procedural rather than factual. The court found that Lively could not bring sexual harassment claims under California law because she did not sign a contract designating her as an independent contractor in the state of California. The relevant conduct also occurred in New Jersey, which created a separate jurisdictional complication. These are legal technicalities, as her team correctly points out, but they're not minor footnotes. They are the reason two of her most significant claims will not be presented to a jury. What will go to trial is her retaliation claim. The court found that she provided enough evidence to support the argument that after she privately raised concerns about the on-set behavior, Baldoni and others took deliberate steps to harm her reputation and career. That includes evidence related to boosting negative content about her online, coordinating with digital strategy professionals, and what the court described in fairly striking language as a plan to, in the court's words, destroy Lively and her career that was put into action. That is the part her team is highlighting, and it is genuinely significant. But calling retaliation the beating heart of the case, as her official statement does, requires a careful reframing of how the lawsuit was originally described and presented to the public. When Lively originally filed her complaint, the narrative emphasis was heavily on the sexual harassment allegations. Those claims were discussed in detail. They were described as foundational to understanding why the retaliation happened at all. The logic was linear. She experienced harassment. She spoke up about it, and the speaking up triggered the campaign against her. Now, with the harassment claims removed from the trial, the story has to be retold with a different center of gravity. The statement she posted on Instagram does this work directly. It describes the retaliation as what the case was always really about. It frames the harassment claims as context rather than core. And it positions the court's decision to let the retaliation claims proceed as a vindication of the fundamental argument she has been making all along. That framing is not entirely wrong. Retaliation claims are serious and consequential. A finding that someone was punished professionally for raising concerns about workplace safety, even if the underlying harassment claim cannot proceed on a technicality, is a meaningful legal and ethical matter. Juries take retaliation seriously. Courts take it seriously. And the evidence the judge found sufficient to send to trial, specifically the documentation around coordinated digital efforts to damage her reputation, is the kind of material that tends to be compelling in a courtroom. But there is a difference between saying that retaliation was always the heart of the case and saying that retaliation is what remains after the other parts were cut away. One of those is a story about clarity of purpose. The other is a story about adaptation. Understanding which one is closer to the truth matters, not because it changes what happened to Lively, but because it shapes how this case will be understood by the public and eventually by a jury. Baldoni's attorney, Brian Friedman, has been a constant and vocal presence throughout this litigation. He has given interviews, issued statements, appeared on programs, and made arguments that were sometimes legally pointed and sometimes simply pointed. His approach has been confrontational in a way that occasionally drew the attention of the court itself. Lively's legal team, in their Instagram statement, noted that Friedman was reprimanded by the court for filing what they described as legally frivolous claims. This is a reference to what is known as a Rule 11 sanction in federal litigation. Rule 11 requires attorneys to certify that the legal arguments they submit to the court have a reasonable basis in law and fact. When a court finds that an attorney has crossed that line, it can issue sanctions. The fact that this happened here is not trivial. Courts do not hand out Rule 11 sanctions lightly, and they signal something about how the judge views the conduct of the party receiving them. Friedman, for his part, has argued that the summary judgment ruling represents a significant win for Baldoni. His interpretation focuses on the dismissed harassment claims and argues that those dismissals represent the court's rejection of the most serious allegations against his client. He has used the word exoneration. Lively's team, unsurprisingly, disagrees with that characterization entirely. The truth is that neither characterization is complete. The ruling is a mixed result. Lively lost her harassment claims on procedural grounds. Baldoni now faces a jury trial on retaliation and related claims. The evidence the court found sufficient to support those claims, including the language about a plan to destroy her career, is not favorable to Baldoni. And the Rule 11 sanction against his attorney does not help the perception of how his side has conducted the litigation. There is also the matter of the trial itself, which is currently scheduled for May 18th. A settlement conference was reportedly scheduled before that date. The Instagram statement Lively posted, which concludes with the phrase "we look forward to trial," reads less like genuine enthusiasm for the courtroom and more like a signal that her team does not expect, or perhaps does not want, a settlement. Woven into Lively's Instagram posts was something beyond the legal argument. She spoke about digital violence, about the ways online campaigns are used to silence people, about the vulnerability of women who speak up and face coordinated reputational attacks as a result. She cited statistics about online abuse. She mentioned children on phones and the need for awareness about digital manipulation. These are not small or unimportant ideas. The documentation in this case, and in other high-profile situations like it, has revealed something genuinely worth understanding about the way public relations and digital strategy can be weaponized. The allegation that professionals were hired specifically to seed negative narratives, suppress positive ones, and create a false picture of a person's character is serious regardless of who the target is. But the way she chose to communicate this sits in complicated territory. When a celebrity uses her own legal case as a platform to speak about systemic issues affecting all women, the message can be heard in two very different ways. It can be heard as genuine advocacy from someone who has experienced something and wants others to understand the pattern behind it. Or it can be heard as an attempt to expand the emotional and moral frame of the case beyond what the court has actually found, to make a jury pool and a public audience feel that the stakes are larger than any one lawsuit. Both of those things can be true at the same time. People can be simultaneously sincere in their advocacy and strategic in their timing. What matters is that the audience understands the distinction and understands that the statistics and statements about digital abuse, while valid on their own terms, are also doing specific work in the context of this particular case at this particular moment. Her agency, WME, added to the moment with a formal statement of support. The language was strong, describing her as demonstrating moral clarity and extraordinary determination. It positioned her as someone who chose accountability over silence in an industry that too often asks women to absorb damage quietly. What the statement did not mention, and what is worth noting, is that WME was at one point also representing Baldoni. The shift in institutional support has been significant, and the timing of this public declaration, immediately following a ruling that sends the case to trial, is not coincidental. Stripped of the Instagram aesthetics and the agency statements and the competing legal interpretations, this case is about a specific and serious question. When someone in a position of relative power, even a powerful person like a movie star, raises concerns about how they are being treated at work, and those concerns are met not with acknowledgement, but with a coordinated effort to destroy their credibility, what recourse exists? That is a question with implications far beyond Hollywood. The mechanisms described in this case, the use of digital strategy firms, the deliberate planting of negative narratives, the effort to control how a story is perceived before it is fully told, these are not unique to entertainment. They have been used in corporate settings, in political environments, in personal disputes that never make the news because the person on the receiving end does not have the platform or the resources to push back. The retaliation claim that is heading to trial is, in some ways, a test case for how courts handle this kind of conduct. The evidence the judge found sufficient to send forward, including the internal communications and the documented efforts to suppress Lively's perspective while amplifying negative coverage, represents a category of harm that the legal system is still developing tools to address. There is something worth sitting within the fact that her sexual harassment claims, which in many ways provided the moral foundation for the entire lawsuit, were dismissed not because the court found them incredible, but because of contractual and jurisdictional technicalities. The court's own language made clear that the workplace environment she described could reasonably be understood as hostile. But the law as currently written could not give her a path to a jury on those specific claims in this specific context. That is not a comfortable outcome for anyone who believes the legal system should be a reliable mechanism for addressing workplace misconduct. And it raises questions about how legal structures designed to protect employees sometimes create gaps that leave people without remedy even when their underlying experience is acknowledged as plausible. This case is heading to a jury. The trial date of May 18th is approaching. A settlement is possible, as it always is, but the public posture from Lively's side suggests they are prepared to see this through to a verdict. Whether that reflects genuine confidence in their evidence or a strategic decision about how the case plays in public perception or both is something only her legal team fully understands. What we can say with reasonable confidence is this. The court found enough in the record to conclude that the retaliation claim deserves to be heard. The evidence around the coordinated digital campaign, the internal communications, the documented efforts to damage Lively's reputation in response to her raising concerns, all of that survived the summary judgment stage. That is significant. At the same time, the framing of this ruling as a clear vindication, which is how both Lively's team and her agency have presented it, requires some qualification. She lost meaningful claims. The procedural reasons those claims failed may feel unsatisfying, but they are real. And the work of persuading a jury, which has not yet begun, will be different from the work of persuading a judge that enough evidence exists to try. What comes next is the courtroom itself. The testimony, the evidence, the cross-examinations, the moments where the full picture is laid out without the benefit of carefully selected excerpts from a 152-page ruling. That is where the actual story will be told, in full, without edited fonts or pretty colors. And whatever the jury decides, the questions this case has raised about workplace power, about digital retaliation, about the gap between what the law allows and what fairness requires, those questions are not going anywhere. They will outlast the verdict, whichever way it goes. If this case has prompted you to think differently about how professional reputations are built and destroyed, about how legal systems handle complaints from people in positions of relative power or relative vulnerability, consider looking more closely at the mechanisms involved. Not just as they apply to celebrities, but as they apply to the quieter versions of the same story that happen every day without anyone posting about them at all.